let's start again with our agenda for today. So this year has been very interesting from the Enlarged Board of Appeal perspective, because next to the two Enlarged Board of Appeal decisions, G1 of 22, G2 of 22, so joint decisions on formal priority, we also had the plausibility decision rendered this year. And we will touch on those, as well as the only currently pending referral, the solar cell referral, which deals with public prior use questions, and also alert you of what we think will likely be the next referral, which will likely concern adaptation of description issues. And then in sections B and C, kind of the usual digest of our selection of interesting cases. Yeah, and with that, I think we can start with our first section on the only currently pending referral, right? Yeah.
Yeah, perfect. Yeah, let's start off with the only pending referral at the Enlarged Board of Appeal. This is the G1 of 23 referral with the title Solar Cell. The referral relates to the requirements for a public prior use, and the title really is somewhat misleading. The underlying case is T438 of 19. This really is a polymer case. The referring board is board 3303 with the chairman, Mr. Semino. And the claim relates to a polymer material, an ethylene alpha olefin polymer. In the claim, the polymer is described in terms of 5 parameters, 2 chemical parameters defining structural units and the aluminum content of the polymer, and 3 mechanical parameters. This is, in this case, the melt flow rate, the density, and the Shor A hardness of the polymer. In its opposition, the opponent relied on a public prior use based on a commercial product that is a commercial copolymer sold by Dow under the name Engage 8400. That's the commercial name of that product, and the opponent relied on this public prior use for an inventive step attack. Now, in the case, it is undisputed that this product, Engage 8400, was commercially available before the priority date and fulfilled all features of Claim 1, except for one feature, and that is the aluminum content feature. So no novelty destroying prior art, but relevant for inventive step. The crucial matter under dispute here is whether a skilled person could analyze the commercial product and, without undue burden, reproduce this copolymer. Now, here the patentee argues that, especially in the field of polymers, it is very difficult to analyze the precise chemical composition and also the internal structure of a copolymer, and that reverse engineering to arrive at a process to reproduce a copolymer really requires extensive research, which would be an undue burden for the skilled person. Now, the patentee here further argues that for a commercial product to be considered prior art, the skilled person must not only be in a position to analyze the product, but also to reproduce the exact product without undue burden. And in this regard, the patentee relies on decision G1 of 92, which says really two important things: chemical, and this is what is underlined here on the slide, the chemical composition of a product is state of the art when the product as such is available to the public and can be analyzed and reproduced by the skilled person, first requirement. And second requirement, where it is possible for the skilled person to discover the composition or the internal structure of the product and to reproduce it without undue burden, then both the product and its composition or internal structure become state of the art. Now, the board, the referring board here, found that there are divergent approaches in the case law when addressing this question. It broke down the requirements set out in G1 of 92 into three aspects. The first aspect is the interpretation of available to the public. There it found that in some Board of Appeal decisions, if the chemical composition of a product cannot be determined without undue burden, the product was excluded from the state of the art. This is the one line of decisions. And in other decisions, only its chemical composition was excluded from the state of the art, but not the other features. So this is the first diverging line of case law. Then in the second aspect relates to the degree of detail for the analysis of the product. Here, some boards require that the exact composition and internal structure of the product is necessary, and other boards are not so strict and allow some degree of uncertainty in the analysis. So again, diverging case law. And finally, the third aspect relates to the requirements for the reproducibility of the product. Here, some boards require that the commercial product must be exactly reproducible. And in other decisions, other decisions are not so strict and also allow some degree of uncertainty here. So in view of this diverging case law, the board formulated three referral questions to the Enlarged Board of Appeal. We put down these three questions for you here. I don't think we need to go through the questions or read the questions aloud for you in detail, but they all relate to the question under which circumstances a commercially available product is not considered prior art. And I think this will be a very interesting case to follow up on, because in polymer cases, it is quite common to rely on data sheets, right, for commercial products. This is standard practice to submit data sheets. And very typically, the information contained in these data sheets is taken at face value. And if it is required that a certain commercial product must be exactly reproducible in order to be considered prior art. So really, if you look at the question 2 here, if this question turns out to be, if the answer turns out to be no to question 2, then this would lead to quite some change in practice. I can probably tell you a few cases from the tip of my head that would have ended in a different outcome if this standard would change. But it will take some time until there is more clarity here. Most likely this will not be decided, well, very likely not before 2026, right? But it's definitely in the meantime worth reading the referral decision, that is T438 of 19, because there might be pending cases where it makes sense to have the proceeding stayed, right? Until the Enlarged Board of Appeal has decided on this question.
On the timing, you probably mean 25 or
25. Sorry, did I say 25?
26, yeah.
25.
Yeah. Or let's see. I mean, as it's the only pending referral, sometimes they also pull it then up front. But I mean, now is also a good time for amicus curiae brief to consider. And yeah, I also think it's a super interesting case. We now have quite some cases on enablement of prior art disclosure. So right, that even for written disclosure, you can also often argue or question whether that actually provides an enabling disclosure, and that of course now in parallel also then applies to a product, because it's a similar question, right? Whether it would require undue burden to kind of reproduce or analyze what has been disclosed. Yeah, but indeed very interesting. And that brings us to the next portion of the webinar presentation, from an actual referral to something we believe to be an imminent referral. And that comes from the examination appeal case T56 of 21 initiated by Roche, where likely questions concerning kind of the never-ending saga at the EPO on adaptation of description requirements might now be escalated to the Enlarged Board of Appeal. And there you probably all know from daily practice that the EPO is one of the very few, and actually the only one of the top 5 patent offices requiring quite extensive adaptations of the descriptions to claims pre-grant. And the justification for that, the EPO sees in Article 69 EPC or 84 EPC, right, that the claims need to be interpreted with the help of the description, and if there's a discrepancy between description and claims, that leads to claim construction issues that can then also lead to a lack of clarity. And there have been in the last years a couple of Board of Appeal decisions where certain boards have put away with this requirement, saying there would be no legal basis in the EPC for requesting this amendment of the description. But so far there has been no referral, but this case here now will likely refer the questions to the Enlarged Board of Appeal. And maybe just the arguments against amending the description, or why also Roche here sought to take this to appeal with the aim of escalating it to the Enlarged Board, is, I mean, maybe the final point: unnecessary costs, time delays, administrative efforts, especially if you're dealing with very lengthy specifications. It's not an unreasonable effort to actually amend all of that description. But what's more is especially the risks associated with the amendments, which often the examiners don't see, but which we in practice then may face later, so that also amendments in the description can lead to Article 123 problems, or even inescapable traps later on in opposition proceedings. That's kind of the first reason. The second reason, which is also highly relevant in practice, that, I mean, in almost all infringement cases that we have where the description has been amended during examination, these description amendments are always, at least the defendant tries to bring in the description amendment as source for claim construction, kind of arguing that the description was purposefully amended in a certain way, so the applicant wanted to show that certain meanings should no longer be encompassed, and so forth. And if you keep that in mind, it's often worth to fight with the examiner for certain amendments not needing to be done, which again increases the timelines and costs involved. And another nuisance at the EPO with the description amendments is, of course, also that on appeal, right, if the Board of Appeal maintains a patent in amended form, the current practice is that it's remitted back to the first instance, and that can also take another year sometimes till the description is actually adapted and a new patent specification published. So also, in our opinion, a lot of reasons speaking against having to amend the description. And here just the background of the case. So here the examining division pre-grant requested adaptation of the description according to the current guidelines, right, which have also again have been made even stricter with regard to adaptations of the description, requesting expressly that all also passages in the description not covering or relating to the claim subject matter really need to be deleted. And depending on which examiner you are facing with, they actually even insist on that. Here, in that case, we also had an interesting aspect that they had these claim-like clauses at the end, and also they are refused to delete them. So the case was then, the application was refused, and the case went to appeal. Roche suggested the referral in the preliminary opinion, which issued in July this year, written by legal member Bühler, put up a concrete suggestion for questions to be referred to the enlarged board and asked the patentee, the applicant, the appellant, to comment on the questions, setting a deadline. And now, just end of October, we see on the register the response of the applicant, where these questions were just slightly modified, but we expect the referral now to actually take place rather soon. There have also been third-party observations, submitting articles. There had a lot of also legal scholars and articles, and also patent organizations have also published their opinions on this matter. So this has now also been submitted to the file. And the questions that are now kind of the amended, slightly amended proposal by the TBA. So these could be the questions that will be referred to. I'll just read them briefly. The question 1 would be, is there a lack of clarity of a claim or a lack of support of a claim by the description within the meaning of Article 84 EPC if a part of the disclosure of the invention in the description and/or drawings of the specification is not encompassed by the subject matter for which protection is sought? So if there's an inconsistency in scope between the descriptions and/or the drawings and the claims. And then question 2, if the answer to question 1 is yes, can an applicant consequently be refused? Can an application consequently be refused based on Article 84 EPC if the applicant does not remove the inconsistency in scope between the description and/or drawings and the claims by way of amending the description? Yeah, so we will keep you posted via our blog on any developments here, but we certainly expect a referral to occur here and also rather soon. Yeah, so that brings us to the 2 actual G decisions that came down this year, or it's actually 3, right? But the priority decisions are kind of verbatim copied. And I hand over to you, Arvid, for the first one.
Turning to G1 and G2 of 22, these were long-awaited decisions related to the entitlement of priority. They were published in October of this year, so fairly recent. And here the board, the Enlarged Board of Appeal, had to decide on 2 important questions. The first one is whether the EPO is competent to assess entitlement to priority. And the second question essentially is whether the PCT joint applicants approach applies. And now, what is the PCT joint applicants approach? This is a frequent case scenario with older, that is pre-AIA, US priority applications. Here the inventors are listed as the applicants in the initial US priority application, and then in the subsequent PCT application, the inventors are listed as applicants in respect of the US only, and the employer is listed as the applicant in respect of all other states. This was the standard practice before the America Invents Act in the US came into effect. So before, I think it was end 2012 or early 2013, it was required that the application was filed in the name, initially filed in the name of the inventors. And here the question comes up whether in a case where there is no explicit assignment from the inventor to the applicant prior to the PCT filing date, whether in such a case the naming of the inventors as applicants in the PCT application for the US only is sufficient to establish that the priority has been correctly claimed. And here we put down for you the two referral questions. Yeah, thanks. Again, there is, I think, no need to read these out aloud. The EBA decision here now puts an end to a long controversy. And in short, the answers of the EBA are that for question 1, the answer is yes, the EPO is competent to assess whether a party is entitled to claim priority. This is head note 1 of the decision. Maybe you can switch to the next. Yeah, thanks. And for question 2, the answer is yes as well. So where a PCT application is jointly filed by several applicants for different designated states, there is a presumption that all parties are entitled to priority. So this is head note 2 of the decision. So in other words, the EBA confirmed the joint applicants approach and put an end here to a long controversy. The EBA justified this decision in particular with the following reasons. First reason is that all parties involved will normally have an interest, right? That an application may benefit from a priority right. Then another reason is that there are no formal requirements for the transfer of priority rights, so no reason to insist on a written assignment. And thirdly, that the applicant of the priority application has to provide support to the applicant claiming priority. So these were the underlying reasons. And for patentees, especially US patentees with pre-AIA applications, this decision is, of course, good news. It means that in most cases, they are formally entitled to priority. And for the opponents, on the other hand, this is not so good news. I think it's likely that in opposition proceedings, the standard practice of attacking the priority of US PCT applications for lack of assignment will probably disappear.
Yeah, or at least decline. Yeah, yeah. But I think especially the second point, this rebuttable presumption, is really, yeah, a clear signal and really change in the practice, because in the past, in the cases we had, it was rather the other way around, that usually the whole yeah, realm of assignments, this is all in the realm then of the applicant patentee, and then it's expected that you are you're supposed to really yeah, produce the exact chain of title. And often in these cases, if time has passed, it's really difficult to prove each step in each of the assignments, and especially if the opponents are then creative and attack all sorts of also national right aspects of assignment and priority, it can get extremely complicated and difficult, and sometimes also dead-end situations. And with this rebuttable presumption, it's of course yeah, much more favorable for patentees.
Yeah, oftentimes this comes up 10 or 15 years after, right? Later on, yeah, after the priority. So yes.
Okay. Yeah, that brings us to the second and then also last G decision for this webinar, and it's the plausibility decision G2 of 21, extremely important decision in the chemistry life science space. I will try to keep it brief, because we actually had a dedicated webinar on this decision and its consequences just 1 or 2 months back. You can find the recording on our blog. And And that was a joint presentation, by the way, with the US colleague, also showcasing the Amgen-Sanofi decision that the US Supreme Court rendered. But just very briefly, what is plausibility, or what gave rise to this referral? It's actually a concept only developed in the case law, so that the Enlarged Board of Appeal here also, again, emphasized it's not a written legal requirement in the law. It's especially prominent in UK patent litigation, where a lot of pharma patents are revoked for lack of plausibility. So in the UK, it is presented or dealt with almost like a patentability requirement. The aim is to avoid these, what the IP blocks called armchair inventions, so speculative patents. And this, what's sometimes called the patent bargain, right? That you should be awarded a patent for only that which you have also really disclosed. So that's why also your application should render plausible that the invention and the technical effects you claim have been achieved at the priority date. The case was crop science agrochemical case, a classic combination claim to the combination of two insecticides. And as often the case in these types of combination cases, the whole fight among the parties was around whether or not a special technical effect was associated with this combination. For these combination claims, usually even a synergistic effect is required if both ingredients are already known for the relevant treatments. And this was also the case here. And to show these synergistic effects, of course, you need to rely on experimental data. And this is then also the issue here, because it revolved around whether or not post-file data of the patentee could be taken into account. Okay, and to the background of the case, or how the facts of the case. So the insecticides claimed the patent comprised data which demonstrated activity and also a synergistic effect against two certain moth species. The opponents filed data that at least against one moth species, the synergistic effect was not present. And then the patentee turned to a third moth species, so a very specific technical effect, claiming now a synergistic effect, at least for that moth species. But for that effect, he also needed to rely then on post-filed data, because that had not been included in the application as filed. And there, the Board of Appeal considered it crucial, the question of whether this experimental report could be admitted and considered in the proceedings or not, because in these combination patents, the whole question of whether the patent is to be revoked or not then depends on whether this synergistic effect can be shown. And in order to take the experiments into account, the board considered the plausibility standard and required the application to render plausible that this technical effect is present, and in this context then referred questions to the Enlarged Board of Appeal. This referral came from Board 3302 Müller as a chairman. He really went to great lengths to analyze all the case law and bucket sorted the cases on plausibility into different buckets, which he termed then ab initio plausibility, or ab initio implausibility, or no plausibility. These were the three categories, and it boiled down to whether also the burden of proof question, right? So whether you would only need as a patentee to show plausibility if the application as filed as such rendered it completely implausible that it would work, or if ab initio you always have the burden to show plausibility, regardless of whether there are serious doubts. We don't need to deal so much with these three categories because actually the Enlarged Board of Appeal refused to categorize in this way. So the Enlarged Board, and you can find more details in the webinar we gave on this topic, they actually didn't see these different categories, but tried to subsume all the previous cases in one common concept. And this is then also reflected in sometimes criticized very general head notes that have been rendered. So this, what you see here now, is kind of the new guidance or the new concept under which you now will have to argue for plausibility and technical effects to be considered. And the first head note reads, evidence submitted by a patent applicant or proprietor to prove a technical effect relied upon for acknowledgement of inventive step may not be disregarded solely on the ground that such evidence on which the effect rests had not been public before the filing date of the patent in suit and was filed after that date. So that is just a general statement that post-filed evidence can be taken into account. And then the second one is more important. That's then the condition. So there, the Enlarged Board stated that a patent applicant or proprietor may rely upon a technical effect for inventive step if the skilled person, having the common general knowledge in mind and based on the application as originally filed, would derive said effect as being encompassed by the technical teaching and embodied by the same originally disclosed invention. So very curious wording that we haven't seen in this form before. So really new linguistic nuances here. So it's not that the effect needs to be somehow disclosed or stated in the application. The requirement is broader. With common general knowledge in mind, skilled person has to be able to derive said effect as being encompassed by the technical teaching and embodied by the same originally disclosed invention. You will see from the analysis of cases that have followed that also the boards of appeal, especially also the referring board with Müller, have had difficulties to really clearly read here what the Enlarged Board wanted to say, but the Enlarged Board in its decision also justified, so they were aware that they word this very generically and broadly, and that this was purposefully done because this whole category of plausibility issues arises in very different contexts and is also very different depending on whether you have a chemical case or a mechanical case and so forth. So I think that's also a reason why they didn't give more specific requirements here. But at least for our part, we are rather happy with it, especially that the case law hasn't become even more restrictive regarding this plausibility threshold. And on summary on possible impact and what else you can take from the decision. So there's also quite some deliberations in the decisions and considerations on the free evaluation of evidence, because this was an important point that in these cases with plausibility, it's actually then an unequal arms situation, because the opponent with his opposition can file all sorts of experimental data, but when the patentee in reply then submits his own experimental data, there he or she should be refused from having that considered due to this plausibility threshold, while the opponent can submit anything. So that's why the decision deals quite lengthily with this fundamental principle which they acknowledge of free evaluation of evidence. And then also confirms that in general, of course, also patentees can file post-published or post-created evidence. The third one is kind of the head note 2 that we just read. What's an interesting point, and there I can refer you to our plausibility webinar recording, is that what we just read, so this decision was on inventive step, right? The plausibility requirement arises at the EPO either under Article 56 inventive step, especially in case of product or composition of matter claims. And in that case, right, the insecticide combination that was a composition of matter claim. So the technical effect arose in the problem solution approach under inventive step. But the plausibility requirement also often arises under Article 83 EPC in our field, especially in second medical use cases, where the technical effect, the medical utility, is mentioned as a feature in the claim. And then the question of whether the application as filed renders plausible this medical indication, the technical effect, then arises under Article 83. And there, the decision makes actually an obiter dicta also on the Article 83 situations and confirms that in principle the same applies, but the standard is different. So the standard under Article 83 is more strict, and there, if you read the wording there, so it's, if you want to check it, it's reason 77 and reason 74 of the Enlarged Board of Appeal decision. There, the Enlarged Board uses terms like the application needs to render credible that the technical effect is achieved. So that's, of course, a completely different standard than this, the skilled person needs to be derived, that it's encompassed by the claims and so forth. So it's really an important decision that the case law will need to digest now when applying this new standard.
Natalie, would you say that the G2 of 21 decision is really in favor of the patentee? I mean, before we had the situation, right, that there was really diverging case practice between two especially important chemical boards of appeal, 3301 and 3302. I understand this to be more in favor of the patentee than at least the 3302 practice.
Yeah,
right?
Yeah, I think that's fair to say. It's definitely not, so I would say the line of case law has become now more liberal, definitely not stricter than before. And in the next section on the material aspects, because this is such a big decision, we also now focused on kind of the first decisions applying G2 of 21. And there you will also see that the majority then rules favorably on plausibility. Yeah, and that already brings us to the next section. As announced, a focus will be on kind of analyzing the first or giving you kind of examples of decisions now applying G2 of 21. And as a second kind of focus topic, we would like to present you a very interesting case highlighting selection invention issues. Yeah, so let's dive directly in it. This is just an analysis that we updated yesterday again. So there were 23 decisions citing G2 of 21. Of course, some of them are just because proceedings were stayed, but and are now again resumed. But a lot of them then actually also apply the new standards, and a lot of them are inventive step decisions, but there are also several that apply this new enablement standard. And what we just wanted to briefly touch on is the actual referral decision. So that has only become available since a couple of weeks. There you see the date of the decision, July 28, the oral hearing took place, where the board applied the standard. It's very interesting to read the minutes and preliminary opinion from that hearing, because their Chair Müller and his rapporteur make clear that while it's clear to them what they will now decide, so that the experimental report needs to be admitted and considered in the proceedings, and that's why inventive step is acknowledged. It's not at all clear to them yet how they can fit this or subsume this under the new standard, and that they need more time to actually digest and categorize it. So that's why it's worth reading this now just recently released written decision of the referring board, where they then rule positively on both of these criteria, right? So that it needs to be encompassed by the technical teaching, and that the skilled person would recognize it as embodied by the same originally disclosed invention. You will also see that actually in the head note of G2 of 21, and that also applies to the to this decision here now, actually this term plausible or plausibility is not used anymore at all. So also in the written arguments, one would now not write, you know, that it's plausible or something, but the standard is this encompassed by the teaching and embodied by the same originally disclosed invention. So it is different. Yeah, and I think we can skip over that and turn. So we selected two cases, one positive and one negative. I picked this case because it's a case where you see this plausibility standard applied to sufficiency of disclosure. So this is a case concerning a medical use claim for a combination treatment. The claim is worded pretty broadly in that a VISTA antagonist, so a functional definition of the first agent, VISTA antagonist, and also the second agent is also defined functionally, so PD-1 antagonist, so very broad definition of the two agents, and then for use in combination in treating cancer, so a second medical use claim, and that's why the issue of sufficiency of disclosure, the issue of plausibility then arises here under sufficiency of disclosure and enablement. And the data provided in the application is a screening assay to identify anti-VISTA antibodies. And a synergistic effect of anti-VISTA and anti-PD-L1 on tumor growth reduction is shown in vivo, but no clinical examples. Yeah, the question here was whether this relatively broad breadth of the claim is justified and whether the application really renders plausible this technical effect. And here the decision was positive. So this is also a decision, if you compare it to the Amgen-Sanofi case, you see that at the EPO in general, specifying binding agents like antibodies via their targets only in the claim is perfectly acceptable and possible at the EPO if you are the first to for example, here find this specific combination to be particularly useful in a medical context. And here the board, I mean, that's common standard stated that, for example, an antagonistic anti-VISTA antibody can be identified based on the description and the common general knowledge. And also from this early in vivo data, it was also, they use here this, it was credible and predictable, right? So that's now the different standard under sufficiency of disclosure, that you require this credible criterion, but they considered it credible from the application that an antagonistic anti-VISTA antibody in combination with an anti-PD-L1 antibody would be suitable in treating cancer. Yeah, so it underlines the importance that yes, you definitely need for these second medical use claims initial data in the application, but on the breadth of the individual agent definition, there the EPO is still relatively lenient as long as you provide disclosure. So in that case, right, they also had this example with the screening assays. So that's definitely recommended if you have a functional definition that you also describe how you could screen and identify further members of the class. Yeah. And with that, I think we can also touch on a negative example.
I picked an example where inventive step and plausibility was denied. Here in T258 of 21, the board found that there was an inadequate disclosure for the purported technical effect. This is a decision by board 3307. It's an appeal against the decision of the examining division. So it's an applicant appeal, not an opposition. The claims in this case were directed to the second medical use of clevidipine for the treatment of ischemic strokes. And it concerned a subpopulation of patients. So a fairly specific medical use claim. Clevidipine was a known drug against hypertension. The application itself was rather short, 20 pages. It did not contain any data, any experimental data at all. Now, the applicant here argued that the claimed use was inventive in view of an unexpected technical effect. The board did not follow this. It stated that the technical effect was neither contemplated nor suggested in the original application. There was no comparison to other anti-hypertensive agents in the application, and for that reason, the board considered that the technical effect was not plausible and denied inventive step. Now, this is a somewhat extreme and a special case, I would say, with no experimental data whatsoever in the application. So I'm really not sure to what extent you can generalize this case, but it definitely underlines the importance to substantiate any technical effect with experimental data. Now, this is nothing new. The EPO has always required evidence for a technical effect, whether in the application itself or post-published, and this, of course, has not changed after G2 of 21. Yes.
Yeah. But for the sufficiency of disclosure cases in the second medical use, the more specific you are, or the closer also the prior art. So if you're really claiming a certain subpopulation and technical effects there, also, I mean, this really then requires the application to render it credible, and this can sometimes even amount to also clinical data being required to show then special effects in certain patient populations, if that is your invention. So it's always depends on the invention that you're actually dealing with, also the standards for showing the technical effect in the application. Okay. Yeah, then let's switch topics from the plausibility case law to kind of the second material aspect that we wanted to focus on today, and that's selection inventions. And there was a very interesting recent decision, T1356 of 21, a Sanofi case, which deals with selection from a numerical range, so something that's pretty common, I would say, but it's interesting because both on the novelty side and the inventive step side, interesting aspects are touched upon in this decision. So here you see claim 1. Let's maybe first talk about the novelty aspect. So claim 1 was to an aqueous pharmaceutical formulation. So it's an injectable insulin formulation comprising insulin glargine. That's a derivative which is a long-acting insulin, but that was known in the prior art. The only distinguishing feature in the claim is this concentration range, that the concentration of insulin glargine is 270 to 330 units per ml. And then there was also a second medical use claim 11, where then the formulation was claimed as for use in the treatment of diabetes. The prior art, insulin glargine as such, was already a product. So that's Sanofi's Lantus product, was specifically disclosed at 100 units per milliliter, so a lower concentration. There was a prior art patent application D12, which also disclosed a range of concentration 100 to 500 units per milliliter. So the 270 to 330 fall within the range. And the first instance and also the Board of Appeal then acknowledged novelty for that range and applied the standing criteria. There are two criteria, right, for this selection of a sub-range to be novel. The first one is that the range is narrow compared to the known range, and this they considered fulfilled here. And the second one is that it's far removed from any specific examples, and also that they considered fulfilled. In the past 5 years or so, there has been a change, or it has been clear that these are really the two criterion that there are. In the past, there was sometimes a controversy of whether already in the novelty assessment also a third criterion, namely the purposive selection criterion, should be used in addition. So that you would also need to argue that this selection has a special technical effect. And there the standing case law is, and this was now also confirmed again, but it's also now in the guidelines and in the case law book, is that this purposive selection criterion is not required for product claims. Here, the appellant opponent was a bit creative and said, yes, he accepts that standard for the product claim 1, but for the medical use claim 11, he stated that for medical use claims, because it's a dosage regimen, and he said the concentration is part of the dosage regimen, that the dosage regimen claims would require per se, according to the G2 of 08 decision, the dosage regimen to be specific over known administrations, and that would also then imply an additional criterion in this novelty assessment. But there the board disagreed on 2 points. Firstly, that this concentration, so they distinguished in the second medical use claim between product features and then for use in the actual use and dosage regimen features, and said the concentration is not part of the dosage regimen. It's part of the product, so novelty of the product then also automatically renders the use claim novel. But hypothetically, they also address this alleged special requirements for dosage regimen claims assertion, and they also refused or didn't consider that to apply. So specifically stating that no special criteria for novelty and inventive step of selection inventions applies in cases of dosage regimen or second medical use claims. So that's the one point in the decision that's worth considering or reading. And the other one, which I found really interesting because it occurs quite often in practice, is what happens if you have several technical effects. So that I think happens really a lot. Also in the application, when you draft applications, you often have these applications which list multiple technical effects, and oftentimes also several of those will be present. Here in this case, the technical effect of having a higher concentrated solution was, on the one hand, that if it's higher concentrated, you need less injection volumes. And that's, of course, favorable. If you have less injection volume, then it's less pain for the patient and also less swelling and so forth. So that this reduced discomfort or pain upon injection, that was the first technical effect. And there the parties more or less agreed that this is an obvious effect, or at least not surprising, that if you have a smaller injection volume, that then you have less discomfort. But the actual core of the invention, or the surprising effect, was that just by increasing the concentration, you suddenly got a different PK/PD profile, especially a flatter and longer lasting effect profile, which is very important for these types of long lasting insulins. So they are also called basal insulins. There you actually want to have a really flat profile. And that was surprising because that couldn't be explained why a change in concentration should have that effect, right? Because the administered dose remains the same, it's just the concentration. And there the appellant argued that even if effect number 2 is surprising, it's just a bonus effect, because you would definitely try to increase the concentration to reduce the injection volume, and then you would automatically arrive at the additional effect of having this PK/PD profile. And that's why the decision is interesting, because I think that you have quite often that you could make such an argument. and there the board disagreed and said that this bonus effect argument, you need to view it pretty strictly, because otherwise you will end up with obviousness pretty often. And they actually said that it's more or less limited to real one-way street situations, where in a one-way street situation, you also have a bonus effect case. But on the other hand, if you have several options, and here, if you actually read the options, yeah, I would say they're not as obvious, but the patentee here argued that there would have been alternative ways to reduce the discomfort without changing the concentration, like, you know, adding additives or putting something on the injection site. So it was a bit creative additional options that they put up, but it was sufficient to convince the board that there was no one-way street situation. And the only other point I want to mention is that another thing we often deal with is the question, what is the correct comparator? So here in the application, the concentration actually tested was 300 units per ml. And in the prior art, we had the broader range, right? 100 to 500. So from a novelty perspective, you would consider both the 100 and the 500 to be disclosed. But the examples in the prior art application were always with 100 units per ml. And there the appellant said, well, this concentration effect that the claimed range has, this also occurs at higher concentrations. So if you go even above 330, so 330 to 500, there you will see the same. And that at least for that part, it wouldn't be a special technical effect over the prior art, but there the board here very clearly said that for them, only the specifically exemplified concentration, and that in that case was 100, they called the range 100 to 500 and even hypothetical. So only the concretely embodied exemplified concentration is the comparator to compare against in experiments. Yeah.
That's really good decision.
Yeah.
Pharmaceutical innovators.
Okay, then the last part, but we can go through it quickly, because we actually have, we can refer you to the case law webinar of our mechanics and engineering colleagues, who also had quite some procedural cases, which of course apply independent of subject matter, technical subject matter. But maybe let's just quickly take a couple, because I see that we are already short on time. Yeah.
Yeah, let's turn to the first formal procedural decision. First one we picked relates to the signature requirement on assignment documents. It's a decision of the Legal Board of Appeal. The applicant here wanted to record a transfer of ownership by relying on an assignment document that was signed, with a simple typed electronic signature, so not with a handwritten signature. The EPO legal division in the first instance refused to record this transfer. It referred to Rule 2 EPC. This rule says that where the convention requires that a document must be signed, this means either handwritten signature or other appropriate means permitted by the president of the EPO, and it concluded that a typed signature is neither a handwritten signature nor a permitted appropriate means allowed by the president. So the it refused the assignment, the recordal of assignment. The applicant appealed, and surprisingly, here the Legal Board of Appeals went even further and rejected the use of any kind of electronic signatures on assignment documents used to record changes at the EPO. And I think we can shorten this. It's interesting to read. The board considers signature in Article 72 to mean only handwritten signature. And this is definitely something to keep in mind in everyday practice, right? Although electronic signatures are very common in the electronic age, it's not sufficient if you want to record an assignment. You have to stay old style here and have the assignment documents signed by a handwritten signature. So stay away from DocuSign or other software solutions
for that type of assignment.
Or
on the other hand, one should actually influence the legislative bodies to here amend then to make the law fit for practice. I mean, the German patent law and civil procedure law was also amended accordingly. It almost seems as if the EPC here hadn't done its homework properly or didn't foresee this electronic signature issues. Just very briefly, this was a case we picked because it concerns a very classic situation that we are dealing with also a lot in practice. So here it was an opposition case. With the opposition, an experimental report was filed. Then the patentee initially filed certain objections against the experimental report, but actually only 1 day before the final submissions deadline in the first instance, they filed a very specific objection to the experimental report, which was then supplemented by a new document, D18, 1 day prior to the oral proceedings. And then the patentee complained that this supplementation D18 comes way too late and should have been submitted with the opposition, and they are not able to rework the experiments of the opponent because they needed this information in D18 to rework it, but they only got it 1 day prior to the oral proceedings. But this here then did not succeed because the patentee should have also raised all of his objections against the experimental report as early as possible, so that then the opponent can respond. So this argument that the experimental report was deficient from the beginning and the opponent should have put in all the information from the beginning, this didn't work here. And also in this case, another interesting fact for the practice, the patentee on appeal complained that he would have needed a postponement in order to carry out the experiments. And for that reason, the document should not be admitted. But actually on file, there was no request from the patentee for a postponement. And for that reason alone, then on appeal, you cannot argue that the document should not have been admitted and so forth. So you should think beforehand of whether this issue of whether a document is admitted or not, whether that's really worth for you to actually go into postponement, because then you should request it. And in our practice, we actually see quite a lot of proceedings now in the first instance, hearings being postponed due to experimental evidence being filed by the Rule 116 deadline, and then the other party requesting a postponement because they cannot react to it.
Very often through the video conference hearings, right? The next hearing will then be within 2 or 3 weeks if the parties agree.
Yeah. Okay, and I think the other ones, these ones we just picked from the webinar from our engineering colleagues, so I think we can skip them, but you will also see them on the slides. They are interesting in several aspects, all relating to changes of your case on appeal, auxiliary requests that were filed in the first instance, but weren't used in the first instance because a higher ranking request succeeded. Then it's always the question with the remaining requests, are they then in limbo? Where are they? Are they automatically in the appeal proceedings? How is their admissibility to be judged? This is one case here where this was decided on and where the board actually said, no, they're not automatically in the proceedings, so they have to be judged under Article 12.4, quite an interesting case. And then just two, quite entertaining cases in a sense now, but for the parties in the situation, always very stressful. You probably all know these situations where the board, you get a new request, you ask for an interruption, or there's a lunch break of only maybe 45 minutes or so. The boards of appeal are really of the opinion that in these 45 minutes, it's enough time for you to really study the request, come up with all the objections, right, or formulate new requests and so forth. So that we also see a lot at the boards that they are, if you then say, but I mean, come on, we just had half an hour or 45 minutes. You cannot expect, you know, to kind of come up with the complete case. There, the boards are relatively strict, and here in these two cases, they really considered such short breaks as that they should have been sufficient, and then did not admit certain objections or requests that could have been developed and filed in these short breaks when they were first presented then on appeal. So this previous strategy sometimes that you said, maybe it's also too risky to then file a new request or objection in the first instance oral proceedings, because then it can also, of course, not be admitted, and you say, let's wait to the appeal. I mean, that's a very long standing controversy of what's tactically the better option here. But there are now many cases that really are very strict on that. Okay, and I think for that, I can just recommend our fantastic colleagues, Matthias Karlhuber, Michelle Kaminski, and Svenja Schwand, who, as I already said, really put a bit of focus on procedural case law. And you can view their recording or also contact us. We are also happy to send you the slide deck. And with that, I think we are finally at the end, a little bit delayed. Sorry for that, but it was our pleasure, and we hope that you could take some interesting insights from this. And we would, of course, love to continue the discussion with you. Either now, if you have time, you can raise your hand, and your video and audio will be activated. But we also understand if you have other plans now, but feel free to also reach out to us in case you want to discuss the one or other topic. And with that, I think we also wish you all wonderful Christmas holidays or holiday season, and all the very best for the new year. And hopefully we can see each other also in person again in the new year.